Whether you're in debt or have never borrowed a cent, you need to know the recent changes in the laws regarding debt collection. Why? Because debt collectors may come after you even if it wasn't your debt to begin with. Just sharing the same name as someone else may get you harassed by debt collectors, and seniors can be especially vulnerable to debt collector intimidation. Hi, I'm Jeff Hoyt, Editor-in-Chief of SeniorLiving.Org. Kaisa Janzen is the Assistant Director of the Helps nonprofit law firm, which helps low-income seniors and others who are struggling financially. Not only does Kaisa know her stuff, but as a young adult, a debt collector mistakenly said she owed them $180,000. In this video, the attorney will explain how new laws protect you, including how often can debt collectors call, how your credit report is protected, how your social media is protected, how your email is protected, what is the 7 and 7 rule. You'll also learn why you shouldn't ignore a debt collector, what not to say to them, why you shouldn't send them even a nickel without knowing the consequences of your actions, and where you can get free legal help. Because Kaisa is in Oregon and I'm in California, we will conduct the interview over Zoom. Hi, it's Jeff Hoyt, Editor-in-Chief of SeniorLiving.Org. And today I have the pleasure of speaking with Kaisa Janzen. Kaisa is the Assistant Director of the Helps nonprofit law firm, which helps seniors and others who are struggling with debt. Welcome.
Thanks, Jeff. It's nice to be here.
I'm glad you could take the time. So I understand there's some changes to the laws that protect seniors and others across the country in regards to debt and debt collection.
Yeah, just in the end of 2021 and updated again recently, Regulation F, the federal regulation that gives the Fair Debt Collection Practices Act, what we usually refer to as the FDCPA, it got a lot more power. We probably all understand that technology moves faster than the law, so these changes were needed, and they gave some really brand new and sweeping protections to anyone dealing with any type of debt collection, really.
So I can hear millions of people who are thinking, oh, I'm not in debt, I don't need to watch this video, so they're clicking over to some other video now. So can we hook them by telling people why you need to care about this even if you're not in debt?
Yeah, you should absolutely care about these updates to Regulation F, because all of us could receive a debt collection notice for a debt perhaps we don't owe, we don't recognize. With the huge explosion of debt buying across the United States, it is not uncommon to receive a debt collection notice for a debt you never even owed in the first place. The more common your name is, the more likely it may be that you get a debt collection notice, John Smith, that doesn't belong to you, but it belongs to a John Smith 2 counties over. These protections protect everyone.
And if I'm a debt collector and I'm looking for $1,000 debt from John Smith, I can call every John Smith in the phone book. I don't care who pays it. I just want the $1,000.
Yeah, it's a sloppy process. Don't give debt collectors any more credit than they deserve. They make more money when they spend less time and effort evaluating things before they send out those notices. It's very much a more profitable business when they just throw it up and see what sticks. And that's what they try to get away with a lot.
So the original law, it's pretty old, right?
Yeah, I mean, well, it depends on how old you are, but to me, 1978 that's pretty old. That was before the internet was widely available or available in anyone's home, really. It was before fax machines on a modern level. Fax machines may feel old to some of us now, but faxes didn't really even exist functionally in 1978 for common businesses. It was before email, it was before text messaging. So the law really didn't have any mechanism for dealing with this type of contact in the actual wording of the law.
So let's leave fax machines aside for a second. I'm more concerned about cell phones, which weren't very popular in 1978. The fact is that, a debt collector calling your home over and over again is annoying enough, but the fact that they have an ability to reach you 24/7 wherever you go, does the Regulation F cover that at all?
It absolutely does. It states that if you have in the past consented to text contact, the debt collector can contact you by that method, but the debt collector has to include language with every text message that's essentially some version of, to stop receiving this type of contact, reply with stop. Sometimes I talk to people who are really tired of the text message contact but I ask them, okay, but have you replied stop? And they haven't. So it's important to do that if you're receiving text message debt collection contact you don't want. And now the regulation F has been so strongly upgraded. If you continue to get that type of contact, it's actionable, which means you can contact an attorney and file a lawsuit. So it's a big deal now.
Wow. So I think that's what they call opt-out language, that every text message
Yes,
from them has to
every
have.
text message from a debt collector has to have an opt-out language. And if you don't want to get those texts, please opt out.
Leaving text messages aside, what about phone calls?
Phone calls have a lot stronger protection now. If you are getting unwanted contact from a debt collector, it's important to know about the new 7-in-7 rule. Now debt collectors can only attempt to call you 7 times in 7 days. That's it. And if they manage to connect with you during those 7 days, then they only get to contact you once during the 7-day period. So if I talk to a debt collector today on Wednesday, he cannot contact me again until 7 days from now. So until, he contacted me at 8 a.m. today, that would be 8 a.m. next Friday, or after 8 a.m. next Friday, that he can contact me again. If you give them permission, however, to contact you sooner, you bet they will, and you bet they can. It's absolutely legal if you say, sure, call me tomorrow and maybe I'll have the money, or some version of that, then you just consented to it. But if they have more than one of your accounts at the debt collection agency, this 7-in-7 rule applies to individual accounts. It's not uncommon for someone who has a lot of medical bills with a clinic or a hospital to have multiple accounts with a debt collection agency. So if you have 5 accounts, that means you could be contacted, or they could attempt to contact you up to 35 times in the 7-day period.
Got it. So it's called 7-in-7 because it's limiting 7 calls within 7 days.
You got it. That's exactly right.
And to be clear, those are 7 unsuccessful calls. They can only
Those
reach
are
out to you and leave messages 7 times in 7 days.
Yeah, 7 uncontacted calls, or 7 unable to connect calls. They're called both usually.
Right. And in your example, if a debt collector talked to you today on a Friday, and they could just slip in, hey, I'll call you on Monday to follow up. If you say, okay, you're actually giving them permission to do something that the law prevents them from doing without your permission.
That's exactly right.
So it's important for people to know, just say no, just say, hey, wait, I don't want to hear from you. They have to wait 7 days to call you back.
Yeah. Don't feel pressure. You don't have to talk to them if you don't want to. They don't get to contact you any earlier. You don't have to say okay to get them off the phone, because that'll only make them call you sooner. Yeah.
Good to know. And then you mentioned texting. If they text you a dozen times in 2 days, if your phone's blowing up, you're saying that is against the law. But the law is only good if you can enforce it. So what can you do if you do get a dozen texts from a debt collector about a single debt over a period of time shorter than 7 days?
The first thing I would tell anyone who's experiencing more contact than is legal is to preserve the record. Keep it. Don't delete those text messages, as much as they might make you sick to your stomach or angry. Resist temptation. Don't delete those text messages. If you can, if you know how to, take screen captures, preserve the evidence. What is going on is a violation of the law, and those text messages on your phone are proof of that violation. These are violations that can be taken to an attorney or a law firm that works on these kinds of issues, and you having that proof will help them help you.
But if I can't afford to pay my debts, assuming it is my debt, how can I afford an attorney to take my case?
Yeah, that's a super good question. And I want everyone to understand that if they are experiencing this type of activity and they are a victim of debt collectors who are breaking the law, you don't have to have money to get help with this type of issue. Most FDCPA litigation firms, if not all, work on what we call a contingency fee basis. All of us are probably familiar with the old school personal injury attorney commercials where they say, we don't get paid unless you do. FDCPA attorneys almost always work the exact same way. Whatever they can get for you through settlement or even a jury trial verdict, they get a percentage of that. It's typically a third. You get the other 2/3, but you never have to come up with any money up front.
Well, it's good to know not only about evil debt collectors, but lawyers who may not tell you about that your case could be done on contingency, that you only get paid, they only get paid if you get paid. So good to
Yeah.
know.
Yeah, it's important to understand too, when you're holding on to that evidence, that's going to make a contingency fee-based attorney much more likely to take your case, because they're going to see that evidence and they are going to be motivated to help out. When they make you money, they make money.
And you have a much stronger case if you have the evidence to show that.
You bet. Yep. Keep it.
Great. So let's say John Smith gets a call saying, hey, you owe someone $1,000. Like, it might be their debt, it might be some other John Smith's debt. It's like, how do I know that I really owe the money?
Whomever put together the language for the souped up Regulation F really liked using catchy number titles, because there's also the 5 in 5 rule. If you get a debt collection call, the debt collector now has to, within 5 days, send you a validation notice with 5 big bullet points and a few extra bonus ones. But primarily, that written validation notice that you get in the mail is supposed to tell you, first of all, the good old, this is a debt collector contacting you, or this is an attempt to collect a debt from a debt collector. It still has that good classic language, but it has a lot more important things. One of my favorite things that the debt validation notice now has to have is a tear-off sheet. So you don't have to drive yourself crazy trying to figure out, well, how do I even request a debt be validated? How do I put together the language and go to different websites? Nope. There has to be a tear-off sheet now. It's usually at the bottom, where you just tear it off and it just has the basic template language requesting validation of the debt. It's much, much easier now to request that. The debt validation statement also has to give you the name and contact of the actual debt collector, along with debt collectors love to keep things shrouded in spooky mystery. They don't get to do that anymore. It has to have the account number of your original debt. It's not uncommon to be contacted by a debt collector and not have any sort of idea of what they're actually collecting for. That's not the case anymore. They have to tell you what they're actually collecting for. They have to tell you the name of the original creditor. They have to give you an itemization, so it's not just a, holy cow, this number is way too high, I owed $200 and now they're saying I owe $1,396. No more of that. They have to itemize why you now owe $1,396 on a $200 debt. So that is a huge improvement. The other big deal is the validations now have to contain an advisory of consumer rights. So essentially, they have to tell you that if you don't dispute the validation notice within 30 days, it's going to be considered valid, the debt. That's a big important thing to understand. If you want to dispute it, you need to dispute it. They also have to let you know now that if you do dispute it, they don't get to contact you again until they actually verify that it's your debt. And one of my favorite improvements, they don't get to post anything on your credit report until it's validated. So that's a big improvement on the way things used to be. Again, this is not just people who know that they're struggling with debt, that are not surprised by debt collection notices. This is for everyone.
Right. So John Smith, who's never run up a debt in his life, gets a notice, hey, you owe $1,000. You're saying don't ignore it. He really has to tear off the form and send it back to dispute it and say, hey, this isn't me. I've never been to Kansas, or whatever the circumstance.
Yeah. And I want to be clear, if you don't dispute it, if you don't have time, or you don't notice, or you've been on vacation, or for whatever one of the millions of reasons we're human beings and paperwork gets overwhelming, all hope is not lost. It doesn't mean that there's suddenly a judgment entered against you for debt, but you do want to dispute it because you can essentially cut off all of that future debt collection activity right at the start.
Because then they have to go back and actually prove the debt's yours before they can proceed any further.
That's right. Yeah, it's much more efficient just to dispute it at the get-go.
So what if they have trouble finding my name, my phone number, whatever, but they see me on Facebook or social media? Can they just post something that says Jeff Hoyt's a deadbeat and owes $1,000?
Yeah, if they do, let me know, because that's going to be a super good case. They are not allowed to do any of that. That's a violation of your privacy, and it's also technically a besmirchment or, it insults your character to have that published to your friends, but it did used to happen. Now they cannot address you or communicate with you in any sort of public forum on social media. They still can attempt to message you, but if they request to be your contact, your friend, or whatever it's called on your version of social media, they have to let you know they are a debt collector and not a fellow fan of, I don't know, DuckTales or Beaches, and sneak up on you. They have to let you know they're a debt collection agent.
Right. So they can't just say, hey, I'm an old classmate. Let's be friends. It's
Yeah,
like,
nothing like
I'm
that.
a debt collector.
Yeah,
They
no
have
more
to spell out.
switcheroos.
Got it. Well, that's really good protection there. And even if the debt's true, they're not allowed to publish it on your
No, they are
Facebook
not.
feed.
Yeah, nobody wants their friends knowing, even though probably all their friends are in debt too, but nobody wants their friends knowing their business. And debt collectors don't get to use that as a mechanism of intimidation anymore.
Well, that's something else good, and that's also in Regulation F.
Yeah, that's also in Regulation F, that you can't be doing anything in a public way with the intent to humiliate.
So I've heard horror stories about people going to buy a car or a house or some jobs. They check your credit before they'll give you a job, and they find something big, fat, ugly debt that was on their credit report that they didn't even know about. So they lose the opportunity on the house, the car, the job. Does Regulation F have any protections in those circumstances?
Yeah, Regulation F is going to be a huge godsend to people going to finance big ticket items and hopefully completely prevent that sort of thing from happening. That sort of thing is not uncommon. When I went to go buy my first car as a young 22-year-old, and I thought I was so grown up, and I went to go finance it, and the bank came back telling me I owed American Express $180,000. I had never had an American Express card. That still seemed beyond where I was at that time in my life. And I was just at a complete loss as to what to do. Eventually, everything got sorted. But if this happened now, I would have been contacted before that American Express debt went on my credit report.
That $180,000, that sounds like quite some teenage years you had there.
Yeah, that was much more fancy living than I had actually lived at that point in my life. And then some. I just want to make sure that people understand that if they do see things on their credit report that they never got contacted for, that is definitely something that an attorney who litigates these types of cases would be interested in. So if you see that happen and you try to dispute it and it's still there, don't pull your hair out. If you're trying to close escrow, keep track of everything that's going on. Make sure an attorney knows about it.
And are there any other new rules that can help seniors in debt?
Yeah, there are a few really great ones, actually. So debt collection agencies now cannot threaten you with a lawsuit if the statute of limitations for enforcement of your debt judicially has expired. What that really just means is if my debt is past my state's statute of limitations, means if they sue me and it's past the statute of limitations, I can file a very short response asserting that the debt's too old, and the court will dismiss the case. That's how statutes of limitation work in the civil justice world. Before Regulation F, in many, many states, it was legal for debt collectors to threaten you with all sorts of nonsense. We're going to sue you. We're going to take you to court. But the debt was really, really too old to actually do that realistically. They just knew it was a scare tactic that worked really well. They can't do that now.
The more knowledge you have, the fewer scare tactics can work against you. But it's nice to know that this is illegal now, against the law. So, and when you mention the statute of limitations, I guess that varies from state to state. But I've heard these horror stories where if you get contacted about a debt you do owe, you owe $1,000 on an old credit card bill that you can't pay, and they say, look, just as a token of good faith, just send us $2, $5, $10, whatever, just to show that you're a good person, something you can't afford to pay. And I've heard that sort of restarts the clock, but all of a sudden that debt now, which would have expired, all of a sudden gets a new life, so to speak, because you sent them a few dollars. Is that true?
In almost every state, that's still true. I really, really feel terrible when people call and tell me they did their best and made a payment, but then all of the information comes out and they made a payment a month before the statute of limitations on that debt expired. But I have to tell them they reset the statute when they made a payment. This is the case in almost every state. A few years ago, Texas actually passed a law saying payment of a debt does not restart the statute of limitations on that debt, which is great law, but that is not a common thing. In almost every other state, if you make a payment on a debt, you're going to reset its statute of limitations. So when you go to settle a debt, if that's what you're trying to do yourself a favor before you make that payment, before you settle that debt, just check on the age of the debt. Check and see when you last made a payment, and then look and see what your state statute of limitations really is. You may find that that debt is too old, or it's right on the cusp of being too old.
Once again, a really good fact to know. And in general, Regulation F, does that apply to every business that's looking to collect on debts, debt collection agencies, as well as debt collectors and other creditors?
Yeah, generally speaking, Regulation F and the FDCPA apply to debt collectors. Regulation F's updated version makes clear that it applies to debt collectors, but also debt collection law firms. And a big improvement, debt buyers. Debt buyers love to straddle the limbo between debt collector and creditor legally, but Regulation F now makes it clear that if you're a debt buyer, you fall under the umbrella of the FDCPA.
And what about the original hospital, credit card company, auto sales, the firm you actually ran up the debt with originally? Are they subject to this?
Typically, the answer is no. The only wiggle room there is if you have an original creditor that's acting like a debt collector and collecting for its own debt and gives its debt collecting arm a unique name or a name that's different than its original name, they are subject to the FDCPA. So if I'm American Express and I decide that I'm going to collect my own debts and open a department that's called Express Collections, Inc., and Express Collection Inc. starts hounding people who owe American Express money, Express Collections Inc. is very, very likely to be subject to the FDCPA too.
Well, there's lots of things people should know about their debt. A big takeaway is here: don't send even $1 to someone hitting you up for debt. Don't ignore the bill, even if it is yours. You can't afford to pay it. Just don't ignore it. You can respond to it. What if a person has more specific questions about debt situation that they're in, whether it's really theirs or not? How can they reach out to the Helps Nonprofit Law Firm?
So they can always feel free to call us whenever they need to. It's toll free. It's 855-435-7787. They can also visit our website at www.helpsishere.org.
Great. Well, thank you so much for taking the time to educate seniors and others about debt collection.
Of course, no problem. It's my pleasure.